right. So, Mr. Mate-Kole, thank you once again for agreeing to speak with us. We're grateful for your time.
Yeah, most welcome.
All right. So, media is rife with reports about the Supreme Court's judgment that some 72,000 acres of land do not belong to the Numo Nmashie family. Some of these lands are very popular places we all know: Madina, Adenta, Gano, Peduase, etc. So first of all, I'd like us to go in a certain progression. First of all, just simply, what exactly does this mean? What exactly does this ruling mean?
Well, it means that the allodial owners have changed. The Supreme Court has essentially overturned the decision of the Court of Appeal, which essentially made the Numo Nmashie family the allodial owners of those 72 villages or 70 villages. And now, since that decision has been overturned, it means that now the owners, the allodial owners of those villages or those 72,000 acres of land are now the boys too.
Right. So okay. So in simple terms, it means that the owners have changed. Now,
yes, the allodial owners. So let me just be a bit technical here.
Right.
So, when they say allodial ownership, what it means is that these are the people who first settled in the area, or the people who initially conquered the initial settlers and became the owners of the land, or the people who have, historically lived on the land or transacted on the land for since time immemorial. And so the allodial owners, they are perpetually the owners of the property. It's just as the UK Crown is the allodial owner of the UK. So in Ghana, we have stools, families, clans who own lands. And in this particular instance, the Numo Nmashie family, at some point in time, based on a certain claim, if you want us to go into the case, based on a certain claim that they made to the government, and because of that claim was favorable, let me put it that way, that claim was favorable, they relied on that claim to claim 72,000 acres of land. And now the Supreme Court is saying that the Supreme Court said that 72,000 acres of land did not belong to them. And the claim that they made was that initially, the government in the 1960s, 1966, passed an executive instrument to acquire 25 acres of land for, I think, television. And when that claim was, when that EI was passed, those who believed to be the owners of those lands made a claim, put in a claim for compensation. The Numo Nmashie family was one of those people who put in that claim. When the claim was put in, initially, the Numo Nmashie family's claim was declined. They said that they did not own those lands. Then the Numo Nmashie family, aggrieved by that decision, appealed in the 1980s. Then, based on that appeal, the appellate court made a favorable determination in the Numo Nmashie family's favor. But mind you, the claim was about 25 acres of land, though.
Right.
I mean, 25, yes, 25, I think, 1,000 acres or so. So the claim was not about 72,000 acres. You follow me? But because a favorable determination was made in their favor, they used that favorable determination to say that the adjoining areas are all for them. And the adjoining areas went as far as the areas you are mentioning.
Mm.
You follow me?
Yeah.
In effect, they were claiming that in addition to the 25,000 acres or so, which was the subject matter of the of their claim. Now they were asking for more. They were saying that 72,000 acres belongs to them. And they were challenged many times by the boys too. But on many instances, the boys too's challenge was thrown out of court. Then, in trying to basically legitimize their claim, they caused the Lands Commission to make a publication that they are registering their interest in the 72,000 acres. Mind you, this was all about 25,000 acres or so. Do you follow me?
Yeah.
They made a claim of 25 acres or so, but they sought to make a claim over more than what the initial subject matter was. And so people started fighting them. And that is what brought about the Supreme Court judgment. Because the Supreme Court is saying that, first of all, your claim was over a small amount. Now we've gotten a favorable determination. Now you are saying that all the adjoining lands belong to you. That in itself is fraud. Right. Number two, they are saying that the determination that was made by the Court of Appeal in 1986, which made them the owners of those lands, was based on false information that they have given to the surveyor. Because the decision was based on a report which was presented by the surveyor. And in making that report, they made representations to the surveyor that the people in those villages or those communities are indigenes of their group or their clan. And so the surveyor presented that report, and based on that, the appeal court made a finding in their favor. But now the court is saying that we have made a lot of decisions, and we know that Madina and some other areas do not belong to the family, it belongs to the stool. So based on our own decisions, and based on the fact that you made false representations to the surveyor and all of this, you cannot benefit from your fraud. And therefore, we are overturning the decision of the appeal courts.
Right.
Subject to certain variations. So they made some variations.
Right.
So as for the claim that they made in 1986, as for that claim, it has not been overturned, but some variations have been made to that that judgment. And that is the Supreme Court. Yes.
Okay, all right. So thanks for the history. So now let's look at the judgment, right? It says in that so the Supreme Court is directing the Lands Commission to expunge all registration records to the Numo Nmashie family. First of all, what exactly does expunge here mean in this context?
Well, it means that if the Numo Nmashie family have been registered as the allodial owners of the land, what the Supreme Court has said is that remove their names, cancel their names from them, remove it from the record. Okay.
And what is the effect of this on subsequent land ownership? So if anybody else...
Because they are no longer the... Yeah, so the Supreme Court even went further to make other pronouncements. It said that all persons who have acquired grants from the Numo Nmashie family in areas which by this judgment have been held not to belong to the said first, second, and third defendants' families and have taken possession of those pieces of land shall not be dispossessed of their interest. They shall not be dispossessed. Follow me. They shall, however, atone tenancy to the relevant stool or family as per the decision reached in this judgment and other like cases on them. So what they are saying is that you don't have a right to go and recover possession by breaking down, demolishing their structures and stuff like that. But they are supposed to simply atone tenancy. So atoning tenancy means that they have to enter into an agreement with them and then possibly pay something reasonable.
Right. And reasonable here means what? Are people going to be...
So let me explain the whole concept to you. So under in the landlord jurisprudence, if you have property or if you own land if you're a allodial owner and your tenants or your lessees or your subjects do not atone tenancy to you, you can lose it. You can lose your title as an allodial owner. Because if they don't atone tenancy to you for about 12 years or more, they can claim to be adverse possessors in law. Do you follow me? So it's important that that atonement of tenancy is done. Now, my fear is that when they say atoning tenancy, some people might construe it as a profit-making enterprise where they will now go and charge exorbitant amounts and stuff like that, making it impossible for people to pay, and then they'll say they are selling their lands.
Right.
Now, this is where the lawyers come in. Now, mind you, the only reason why this judgment has been given is because the Numo Nmashie family, when they went for their small 25,000 or 25 acres or so, when they went for that size of, and it was given, if they had limited it to that, this would not have happened.
Right.
But they exceeded it and they were looking for more. And that is how come somebody has taken them to court and has won. Do you follow me? In the same vein, you must also know that the Supreme Court can also overturn its own decision. It can overturn its own decision. I'm not the wrong decision. What I'm saying is that if you are an owner of property and you have paid valuable consideration for the property, you pay no or any other person, and for some reason, because of this judgment, somebody is trying session by asking you to pay an incredible amount. You have a right to take the person to court. You understand? Right. You have a right. And I don't want to be too technical. But sometimes you have to be a bit technical in order for people to understand that we operate in a nation of laws. Now, look, there are different interests in land. There's the allodial interest, which is the highest interest. There's customary freehold, common law freehold. There's usufructory interest. There's customary tenancy. All these interests can exist on the same piece of land. And all these interests are registrable. Now, if you, for some reason, are a usufructory interest holder, so a usufructory interest holder is somebody who perhaps, because they are a subject of the stool, do you follow me? A subject of the stool, so they could be a subject of the boys' stool. Because of being a subject of the boys' stool, they are in possession of the land, and they have been in possession of the land for a period of time. They are protected because they are usufructory interest holders. And what that means is that they ought to go and register their title as usufructory interest holders so that they are recognized as such. Such people, if the stool comes to them to say that they should pay exorbitant amounts of money to them, if it were me, I will fight it in court. Then we also have people who bought in good faith. I'm just giving you instances. These are not all the instances, but just giving you a few instances. These are people who bought in good faith. Somebody did a search at Lands Commission and found Numo Nmashie family's name there, entered into an agreement, and then paid them valuable consideration for the land. That person is protected by law. That person is a bona fide purchaser for value without notice. You follow me? And for you to ask that person to pay an enormous amount of money to you for that person to stay on their property is unreasonable. Right. And therefore, the court ought to determine. So what I'm saying is that, yes, atone tenancy because they don't want to lose their right as allodial owners, or they don't want you to create a separate interest called adverse possession, or they don't want your interest to override theirs. So you have to atone tenancy to them. But the atonement of tenancy should not become a situation where it becomes a money-making venture where people are now extorting enormous amounts of money from homeowners simply because a decision has been made in their favor. Because if they do that, they will end up like the Numo Nmashie family. That is where it will end you.
Right.
You will lose it.
Right. Now, I'm interested in finding this out. I mean, if and back to the direction to the Lands Commission to expunge the registration to the Numo Nmashie, all registration to the Numo Nmashie family. What is the effect on that on other registrations? So does it mean that if I bought land from somebody who bought it also from the Numo Nmashie family, and I went to the Lands Commission, does it mean that by expunging the Numo Nmashie family's registration, my registration has also been wiped off the records? Is that what this means?
That's what it means. So,
Wow.
the thing is, so it's like this. You see, once it has been established that the title or the judgment that they got was fraudulent, and consequently the registration that came out of that judgment was more or less, let's call it a mistake. Do you follow me? So every fruit that is born out of that bad tree is also bad.
Okay.
Automatically. So you cannot rely on that that tree any longer. It has to be uprooted.
Right.
And when it's uprooted and they throw it away, then everything that is with it will be thrown away as well.
Okay. Doesn't this create a loophole of a sort in the system? Because now, if everybody's records have been wiped out, does it give certain fraudulent individuals the ability to just...
No, what I'm saying is that now the Lands Commission has been directed to expand the Numo Nmashie's family's name from the records. Now, what it means is that all those of us whose title emanates from them, it means that our titles are also bad.
Right.
Do you understand? So nobody can get a title from Numo Nmashie family in respect of the 32,000 acres again, going forward. Am I clear? Now, what I'm saying is that, but it is not a bad thing that you registered your title, because it is evidence that you comply with the law. And if you can show that before buying the property, you did a search, and the search showed that the land belongs to the Numo Nmashie family, right? And based on that search, you went ahead and paid money. And at the time you were going onto the land, there was nobody in possession of the land. The land was bare land. And you built on it, and you have registered your title. It means that you are a bona fide purchaser for value without notice. You'll be protected by law. You are called equities darling. And once you go to court and you make those arguments, and you ask the court for a declaration of title, the court will declare title in your favor. And once that declaration of title is made in your favor, the Lands Commission will have to register your interest or maintain your registration based on the judgment. So based on the judgment, you have good title. Okay.
So
I'm only saying this not because I'm saying that we should resist the atonement of tenancy. No, atonement of tenancy is good, because I'm saying that every allodial owner, you have to atone tenancy to them. Right. It's a grievous offense not for you to atone tenancy to the allodial owner. In fact, they can re-enter and repossess your land if you don't atone tenancy to them. But what I'm saying is that I don't want a situation where, because of this, people are going to charge outrageous amounts that the landowners cannot pay. And for that reason, they will now dispossess them of the land and now start selling the land to other people. Do you follow me? Yeah. What am I warning is that if that is the situation, then they also stand a risk of losing their title against people who cloak themselves with the law as well and go and seek a declaration of title against them.
Okay, so the reason why I was asking the question earlier was just to find out if this this create any loophole at all? So if now all the records have been wiped out, can individuals who have bad intentions go back and say, look, okay, I own this piece of land when they actually don't own this piece of land? Because then if the records are not there to show,
No. So if the records are wiped out, what it means is that it now creates a clean slate. And what is going to happen is this. And mind you, some of these people have already won judgments already. In the Supreme Court judgments, they are talking about cases that they had ruled on in those areas, and then which made them discover that those lands are stool lands and not family lands. You get me? So already there are some judgments existing which contradicts the Numo Nmashie's assertion and registration already. That's number one. Number two, it doesn't create a loophole when you atone tenancy to them. Because when you atone tenancy, if you humble yourself and you go atone tenancy to them, they will give you a document. And that document can be used to register your title to the land.
Yes, but so how do they know that this person coming to atone tenancy to me actually owns the land they say they own?
That is a very good question. That's a very good question. And that is where some people can take advantage of it to defraud other people. Now, and this is what ought to be done. Now, before somebody comes for a grant, what ordinarily ought to be done is that the grantor, which is the allodial owner, must go and see the property and inspect it. You follow me? And then they'll have to do a site plan for the person that they are going to give the grant to. So, for instance, if I go and see the boys too, that I want you to regularize my interest, what will happen is that they with me to the land, and then they'll go and inspect it and confirm that, yes, this building is for me. I open the gate for them. The caretaker is my caretaker. The gateman is my gateman, everything. And then they will also get their surveyor to do a site plan for me in my name. And then they'll prepare the indenture and everything. And then we agree on the amount, and then the payment is made. And then I will take that document to Lands Commission. I will stamp it and register it. And then it means that I would have perfected my interest in the property. Do you follow me? If that procedure is followed, I don't see how that problem can arise. Also, the rule is that the land registrar is also not supposed to register an interest in land when he suspects that the applicant is not the one in possession.
That might
you
be
get me?
Determine if the person is not
yes.
them with something that proves in the slightest way that they actually own the land.
Yes, I mean that is true. What you're saying is true, but I think that it's very important for them to try and establish possession before. But let me tell you something. Look, the lesson from all of this is that fraud will not benefit you in any way. Because if somebody takes a document, if somebody goes to the stool and takes a document on land that does not belong to them, and they seek to use that and they seek to register that interest, or they seek to register their interest using that misrepresentation, it constitutes fraud. And even after 40, 50, or 60 years, that particular transaction can be set aside. Do you get me? Moreover, if I'm in possession of land and you go and see the boys too, and they give you a document, meanwhile, you know that in the truly speaking, you are not the owner of this property, and you come and you want to oust me from the property, do you think I'll sit down and let you take over my property just like that? I'll take you to court.
But what will be their proof if they go to court? Because the documents that could prove that they own it have all been wiped out.
That is why, you see, the thing is, that's why I said you have to see your lawyer, because the fact that a decision has been given by the Supreme Court does not mean that you also don't have any rights.
Right.
Right. Now, let me give you a provision in the law. Section 121. Overriding interests. It says Section 121(1) says that unless the contrary is recorded in the land register, a land or an interest in land registered under this act is subject to any of the following overriding interests. What it means is that if you have a land certificate, right, that land certificate is subject to some other thing. You follow me? Now, let me show you that other thing. We will find it in, there are many of them, but I just want to show you one, just one. Okay, there's one which says a right or in the course of acquisition, a right acquired or in the course of acquisition by prescription or under the Limitation Act. So you can also get somebody who can use this Limitation Act statutes to defend themselves from somebody who wants to take their land fraudulently. There's also one, 1F, 1211F says a right, whether acquired by customary law or otherwise, of a person in actual occupation of the land, except where an inquiry is made of that person and the right is not disclosed. So you go and take a land certificate and then enter somebody's land, and then don't go and ask the person how they came by the land. Don't ask them. Assume that because of a certificate, you are going to break down their walls and stuff. This rule shows that what you are doing constitutes fraud, because that person has an overriding interest in the property. You follow me? So once you have an overriding interest in the property, you cannot just go and take a lease from the stool, then quickly run, go and stamp it and register it, and then come and try and demolish a property that you know already exists where people are living, and say that it is fraud, and it will be set aside, just like the Numo Nmashie family's judgment of 1986 was set aside.
Right. Okay. Yeah. I have very limited time, but quickly. So who the boys too? So it's just boys too and 13 others. Who exactly? Yeah. How do we find them? You know, how do I know where?
Well, unfortunately, they don't list the 13 others. But from my reading of the case, it appears these are people who lived on the various areas in the 72,000 acres of land that they thought to recover.
Right. So if I want to go and atone tenancy, now I've heard the news. I own some land.
No. So they are saying atone tenancy to the boys too.
Exactly. So how do I know who they are and how to find them?
The boys too.
Yes.
So I think that there's the two factions. There's the Teshi and the Nungwa. So it's a stool land. So I believe that they either they belong to the Teshi or so Teshi faction. All right. So you just have to make inquiries. Teshi faction, and then you also ought to ensure that when you enter into a transaction with them, and this is very key, when you enter into a transaction with the stool, please, what you are giving to the stool is a token. You are not, when you pay them money, that doesn't mean that you have paid. When you give them money, it is actually a token, because by law, stool revenue is supposed to be collected by the Office of the Administrator of Stool Lands. They have an office at the Lands Commission. You see, so if you want to show that you have paid land in Ghana in respect of stool land, then you have to be paying that money to the Office of the Administrator of Stool Lands. What you give the chief is not the pay. It doesn't mean you paid for the land. You have just paid for a token for your peace of mind.
Right.
But the actual payment should be made to the Office of the Administrator of Stool Lands. And this is a constitutional provision. I think Article 267 of the Constitution says so.
Right. Okay. So quickly, just some piece of advice for two categories of people. One, people who are buying lands generally in other areas. What advice would you give them from this case? Number two, advice to people who are probably in the process of buying lands within these lands within the 72,000 acres of land, or people who have intentions of buying moving forward. What advice would you give them?
I would advise them that, first of all, please use lawyers. Use lawyers, because now you can see that because of a decision made by one court, the Supreme Court, now everybody is running helter-skelter. They don't know what to do.
Right.
It is the lawyers who understand these issues and the lawyers who can advise you on what to do. Now, just as I was saying, if you, at the beginning of the transaction, you did your due diligence, you conducted your searches, you did your high court search, your town and country planning or land use and special planning authority search, lands commission search, you did all of these things. And at the end of the day, you paid money, valuable consideration. There was nobody on the land, and you entered the land and you built. You are covered because the law will protect you.
Right.
Whereas another person who just decides that they want to do everything on their own, so they draft their own agreements and do their own things. Unfortunately, there's little that anybody can do for you because you're not protected by law. You see, the reason why you're protected by law if you use a lawyer is that in Ghana, even a conveyance, that is a legal document, a transaction affecting land, can only be drafted by a lawyer. And that's a lawyer in good standing. So if you're a lawyer who has even been suspended, that if you draft such a document, that document is invalid.
Right.
You understand? So it's very important for you to get a lawyer to guide you, because as we sit here, I cannot tell you all the rules on conveyance. It took me many, many years to learn some of these things. So you just get a lawyer, make it easy. The lawyer will help you, take you through the steps, hold your hand, make sure that you are protected. And if any issue arises, that same lawyer will take you to court and assist you.
Right. Thank you so much. This has been a good conversation, and we're grateful that you could join us.
Sure. Thanks. Thank you. Bye.